It's not constitutional. That's what a Gainesville attorney says about 9 former strippers of a nude club in Alachua County who are now out of a job.
And he's filing suit on behalf of one of them as well as 3 employers. TV 20's Hawa Ezel tells us who else is affected by the new state law.
The state of Florida now requires strippers to be at least 21 years of age.
The law is called HB 7063, just passed this year.
A lawsuit filed by Serenity Boucher, Cafe Risque, and 2 other adult establishments claims the new law violates their First Amendment and equal protection rights.
You know, what constitutional rights does a dancer like Serenity have? Well, she has all her constitutional rights.
I got the chance to speak with Boucher's attorney, who says in his eyes the new law is unconstitutional.
So the idea that that adult residents of the state of Florida don't have the same rights as people who are a couple of years older than them, it doesn't make any sense under the Constitution.
The federal suit claims at least 9 women under the age of 21 perform at Cafe Risque and have since lost their jobs.
She has no livelihood. She's out of a profession.
The law doesn't only apply to strippers at these clubs.
Whether they are performers or cooks or DJs or security, they can no longer be employed. And that affects what you might think of as strip clubs. It affects adult theaters and also adult retail stores.
And the consequences are high stakes.
If someone slips by with a particularly good fake ID, that club is strictly liable. And if it's a nude club, such as Cafe Risque in Micanopy, that's a 3rd-degree felony. That means someone's going to jail for that, even though they didn't know and even though they tried very hard to comply with the law.
Ettinger and his client are asking for attorney's fees and other unspecified costs. In Micanopy, Hawa Ezel, TV 20 News.